Peter Neufeld is a nationally recognized civil rights lawyer who spent 35 years trying cases on behalf of victims of police misconduct and wrongful convictions. Peter's perhaps best known for his work in co-founding and co-directing, along with Barry Scheck, the Innocence Project at the Benjamin Cardozo School of Law in New York. That Innocence Project, as we've already heard today, has been responsible in whole or in part for exonerating most of the more than 300 men and women who've been cleared through post-conviction DNA testing. Peter did his undergraduate work at University of Wisconsin and received his law degree from New York University School of Law. He's published numerous articles pertaining to wrongful convictions, and he's co-author, along with Jim Dwyer and Barry Scheck, of the book Actual Innocence, which I'm sure most of us have probably read, that recounts much of the work that the Innocence Project has been responsible for. So please join me in welcoming Peter Neufeld.
Thank you. Thank you all, and thank you, Neil, for the invitation to Simon Fraser. Gary, I meant no disrespect. I mean, I've known Gary and Richard and I have been thinking about these issues to try and enhance the reliability of the criminal justice system for far too long. And actually, I would have said that Gary was the grandfather of it all, but his hair isn't as white as mine, so I dare not do so. But even though I'm supposed to be talking about forensic science, I'll give you one brief comment about composite sketches. I just couldn't resist. So our newest data came out at the IP on the first like 340 DNA exonerations, which is different than the data set that's kept at the University of Michigan, which is a much larger data set of all wrongful convictions, even those not cleared by DNA. And when you look at our set, you find that an overwhelming majority of the wrongfully convicted are African Americans. And when you look at the African American subset, you find that a majority of those cases involve cross-racial identification. And a lot of those cross-racial identification cases arose in the context of the composite sketch. And in those cross-racial identification composite sketch cases, we subjected them to different leading scholars in America who are experts in anthropology and sociology, black studies, other things like that. And the one thing they constantly told us is that these are not composite sketches of individuals. These are composite sketches which tend to be very stereotypical of the black youth, okay, the black young man, and from which many, many people could see resemblances, rather than actually trying to describe somebody of a much more individual nature. So that's one of the fundamental problems that we're beginning to realize with using composites. So I think what I'm going to do is, how do I do this, which goes forward just that way? So I think I'm going to start with something that happened just, 10 days ago, okay? So Keith Harwood, and the date on that is wrong, it's not 1983, it goes back to 1982. But take you all back, and I know that you're Canadian, but if you can imagine Virginia, right, where things started a little bit south of the border a long time ago, there's an area called Newport News. Newport News on the coast is the home of Navy bases are nearby, shipyards are there, and in early 1982, the USS Vinson pulled into port to have some work done on the aircraft carrier. And as you can imagine, as an aircraft carrier, you're talking about 2,000 to 3,000 sailors getting leave, okay? And when they got shore leave that night, at a home about 3 blocks from the shipyard where the ship was in dock, an intruder broke into the home of a married couple who had 3 small kids in the next bedroom sleeping. And the wife was awakened and turned and saw this stranger with a tire iron beating her husband. And eventually that perpetrator beat her husband to death. And after he beat him into unconsciousness, he turned his attention on the wife. And during the next 2 hours, he repeatedly raped that woman. And finally, he departed. But to make it more difficult for her to see him, he took one of the diapers from the baby that was in the next room and put it on top of her face so she wouldn't be focused on what he looked like. But she did get a chance to see him. And she described her perpetrator as a young white man, clean-shaven, who apparently was wearing a Navy shirt. And the Navy shirt showed certain bars on one arm, and on the other arm, an insignia. Okay? And to the police, that was an indication that it must have been somebody from the USS Vincent, because that was the only ship in port. It had just arrived in port the day before. Everybody was unsure. It was probably somebody from the ship. During the course of the crime, the perpetrator had bitten the victim repeatedly on her legs. No question about it. And so they had those bite marks photographed the next day. They then took the photographs of the bite marks and turned them over to the forensic dentist who worked that section of the state, who worked in conjunction with the leading naval dentist in Virginia. And what they did is they went through hundreds and hundreds of naval records of enlisted men as opposed to officers, because the person didn't have any stripes on his epaulets, okay? And examined their dental records to see if they had anything even approximating the kind of bend that this bite mark seemed to show on one of the incisors next to the two front teeth. And the Navy doctor working with the forensic dentist were able to sort of find, 15 or 16 people who seemed to share that characteristic. And then they took those 15 or 16 people and they had them make dentitions, okay, as you would have if you were going to the dentist at some point in your life to get a crown made. And they took those impressions and they had the forensic dentist compare them with some of the details they saw in the photographs, and they were able to eliminate all 14 or 15 of these guys. Okay? So they were back to square one, an unsolved case. Fast forward 6 months, and this young man, Keith Harwood, who's shown in the photograph here, is arrested in a domestic dispute with his girlfriend. And she has him arrested and says that during the dispute that he bit her on the shoulder. And so the police remembered, the guy who committed this other crime was a biter. Keith was one of the 15 people they looked at, but excluded, but now he's biting her. We have to take another look at this. So the police brought the victim down to the station, down to the courthouse when he was arraigned on the domestic violence charge. The girlfriend dropped all charges that day, so he was never prosecuted. He still had no criminal record. But the officer brought the woman in. The woman said, I can't identify him. The officer was not necessarily impressed by that, thought because she had a diaper over her face and because she was so traumatized that she just might not be able to do it under those circumstances. So instead what she did is she asked Keith to make a new dentition. So he made a new dentition, and this time they sent the dentition along with the photographs up to one of the nation's leading forensic dentists who was employed by the New York State Police doing all their forensic dentistry for them, as well as freelancing around the country. He was one of the founders of an organization called the Board of Forensic Odontology. That's a fancy name, odontology, for dentists who get to pick out bite marks. This guy, who was the forensic dentist up there, took a look at it, was told, in fact, that the reason we focused on him is that he had been recently arrested for biting his girlfriend, and he was one of the original 14, and he is white, he is young, in some ways met the description, said, yup, it's him. Not only is it him, but I can say, in all probability, it's him to the exclusion of everybody else on the planet. That it's extraordinarily unlikely that anybody else alive on this planet could have caused that bite on that woman's leg. That's how unusual his teeth are, and that's how well they match the photographs of the injuries on her legs. Dr. Levine's report was then given to another forensic dentist who worked out of Virginia. He independently, that's what he said, viewed the photographs and the dentition, and he too said, I can say this is a textbook case to a reasonable degree of scientific certainty. Those marks were made by Keith Harwood. So you have now two leading forensic dentists who agreed to testify for the prosecution. The defendant says, I'm innocent, I didn't do it. After all, the description says clean shaven, and I had the mustache. In fact, the same mustache you see in this picture. I've had it for 3 years. I've never shaved it, and she doesn't mention it. They just said, well, she probably was so traumatized that she just didn't pay attention to it at the time. He gets prosecuted. His lawyers then try and retain another sort of highfalutin forensic dentist from Harvard. And he looks at the dental records, he looks at the photographs, he looks at the report of the prosecution experts, and he says, nope, I agree with them, it's a match, it's his to the exclusion of everybody else. They go back to the original forensic dentist who said that he was excluded in the 14, and he goes, oops, I must have been mistaken. I now look at this more carefully, and indeed it is a match. Now you're up to 4. Then the Navy dentist is referenced, and he looks at it and he goes, yep, it's a match. Now you're at 5. 5 forensic dentists all said this is the guy to the exclusion of everyone else. Keith goes to trial. He's convicted of capital murder, but for the fact that his mother pleaded and begged before the jury during the sentencing phase, he probably would have been executed. They showed mercy and sentenced him to life without parole. It was reversed on a technicality, had to be retried a year and a half later. New defense team, they couldn't go back to that same dentist up at Harvard because he already sided with the prosecution. They couldn't call him. So they went out and found a 6th dentist, somebody else who was well known up in Richmond, Virginia, and was board certified. And they showed him the photographs, and they showed him the dentition. He said, can't help you. I too think it's a match of him to the exclusion of everybody else. 6 dentists all saying it's his, it's a match, it's a perfect match, and it couldn't be anybody else. He's convicted and sentenced to life. In 1983, then again in 1984 and 85. A few weeks ago, we completed DNA testing. The woman had said that the only man she had slept with was her husband. And DNA testing was done not only on the rape kit, okay, including semen that had been on her thigh when she reported this to the police, as well as inside of her, on semen that was recovered from a blue towel that she put on immediately after being raped that had a semen stain on it, and a semen stain that was found on the baby's diaper, the police thinking at the time that perhaps the perpetrator handled that diaper after he had ejaculated when he was working with the victim. Again, a single semen stain, a single male profile, all the testing on the rape kit, all the testing on the towel and on the diaper, all came to the same conclusion. One source, one person, not Keith Harwood. They run it through the National Convicted Offender Database, and they get a hit on another man who also had been a sailor on the USS Vincent, but was clean-shaven at the time, who subsequently, when he was discharged from the Navy, had been arrested and convicted a number of times of abducting and assaulting women. And in fact, a few years ago, he died while in prison serving a 20-year sentence on another case. So that's the case I wanted to start off with today. And I wanted to talk about what are the problems with forensic science, not just in the United States, here in Canada, around the world, and on how much we, as a criminal justice system, have unfortunately relied on forensic science, even where, okay, it hasn't really passed the rigors of other applied sciences, even where it may not be adequately validated or its reliability demonstrable. And one of the problems in the criminal justice system, unlike with clinical laboratories in Canada or the United States, is that very often the validity and reliability of the forensic science is determined by scientifically illiterate lay people. In the United States, for instance, we have an FDA. And the FDA is a group of scientists, right, who, when a pharmaceutical company or a manufacturing company that has a device wants to put their product or their drug on the market, it's first, the data is first shown to this group of scientists. They evaluate its validity. They assess its reliability. They determine with what parameters it can be used. However, in criminal justice, there's nothing like an FDA at all, okay? In criminal justice, the way it is determined whether a certain forensic discipline or forensic test result can be subjected to jurors is simply what goes on in court, okay? So the decision is made by two generally scientifically illiterate lawyers arguing back and forth about the validity of a particular test or discipline. They're making the argument before a scientifically illiterate judge. And by the way, I don't mean that in a disparaging way. It's just the truth, okay? I mean, I don't know about if any of you are law students, but hey, the reason I went to law school is I didn't even take organic chemistry, okay? Because had I, it would have been, one of those D's. And a lot of us are like that way. It's much easier to cross-examine a police officer or a lay witness. Somebody shows up on the witness stand with a white lab coat, our knees begin to buckle. That's the reality. So you have two illiterate lawyers arguing a case before an illiterate judge so that ultimately 12 scientifically illiterate citizens can decide how much weight to give this scientific evidence. It's idiotic. We would never allow that as a civilization when it came time to assessing the reliability and validity of a medication that your doctor wishes to prescribe to you. We want checks and balances built into our system so we can have confidence that if my kid's showing signs of a bad throat and I take her for a test for strep throat, I'll get the same result in Vancouver as I would get from a laboratory in Toronto, right? That's what you want. Well, why shouldn't we have the same kind of requirements for forensic science where life and liberty is at stake? Or at least in Canada where liberty is at stake. In the US, you get both. So that's the reality. And how did we get there? And we got there because if you went back in history, there was something that happened a long, long time ago where we had a double standard for forensic science and forensic laboratories on the one hand and clinical laboratories on the other. One of the things that you realize when you look at DNA, and we look at DNA at the Innocence Project not simply because it allows us to look at old cases and decide whether or not they got it right the first time, but we look at DNA because DNA, long before it was ever used in a court of law, had a different application in science. And the other applied science for DNA was medicine. And consequently, before it ever got used in a courtroom in North America, there had been tens of millions of dollars spent on basic research, on applied research. There had been thousands and thousands of peer-reviewed articles, people replicating the results, people refuting it back and forth. That whole noble scientific method had been followed. Now, in contrast to DNA, most of the disciplines that we see being used by law enforcement today never went through that kind of rigorous process. There were disciplines that were developed by and for law enforcement. I mean, think about it. Where else would you compare shoe prints but in a court of law? It has no other civil application, or bite marks, or hair microscopy. Only criminal justice. And so the people who developed it were not that necessarily steeped in the scientific method, in the scientific traditions. So you didn't see that basic research, you didn't see the applied research, you didn't see the exhaustive peer review, and fundamentally, there wasn't some, central entity that the data would pass through and be evaluated to see, is this valid or does it not pass the test? Never happened. And without those kinds of controls, you had forensic science developing in a completely different way than clinical science. And when it developed and came into court, there was never any kind of meaningful scrutiny given to it. Let me give you an example, And the example, since I gave you a bite mark case today, is bite marks. So the first leading case in the United States involving the admissibility of bite marks, and I'm only giving you this for illustrative purposes, was a case called People versus Marks. It's an appellate case in California in 1975. And in that case, they acknowledged that there was no established science of identifying persons from bite marks. It hadn't been shown in the case. But they didn't even in that case have a hearing where experts for and against would, raise all the applicable scientific issues. In fact, one of the most fundamental problems whenever they do have a judicial hearing involving the validity of a forensic discipline is that they would consider the relevant scientific community simply comprised of the people who work for crime laboratories who apply the same discipline in criminal investigations or in criminal prosecutions, not realizing that lots of people in social psychology, statisticians, other areas of science and mathematics would have a lot to say if they were asked to weigh in. But they were never asked to weigh in, and the only people who weighed in were other forensic practitioners working for crime laboratories whose livelihood depended upon the perpetuation of this particular discipline. Okay? It is a self-defeating approach cognitively to having a critical evaluation of the virtues of any particular process. So that's what happened in marks. And I'll show you the next slide because it's kind of interesting. We did this for bite marks, and hopefully you'll appreciate it. Don't write anything down. All I'm telling you is we then traced this case into a couple of dozen other appellate decisions all around the country which cite marks for why this stuff is reliable and valid. In other words, none of these other cases had independent hearings to decide whether this stuff was nonsense. Rather, they simply would quote a sister jurisdiction in another part of the country, in this case California, and say the decision has already been made for us. We'll adopt their thinking and say it's valid in our state. You know, whether you've thought about science or not, that kind of thinking, that kind of process is going to get you into a lot of trouble. And for bite marks, we've already developed the fact that 24 cases in the United States, people were falsely prosecuted and or convicted based almost exclusively on bite mark evidence, only later to be exonerated through DNA. It's a big problem. And it's not just bite marks. It's all other forensic applications, okay, other than DNA. And you can see here our most recent chart showing the contributing factors. And of course, as Gary pointed out, the leading one was misidentification or mistaken identification. But you have to remember when you look at these numbers on this chart, these numbers don't mean a lot. And the reason they don't mean a lot is that they're taken from our data set. And our data set is very special. Our data set is comprised of cases where DNA testing can be dispositive on innocence or guilt. And when we first started out, the overwhelming bulk of the cases that we worked on was sexual assault cases. And as Gary pointed out correctly, in a sexual assault case, the primary evidence tends to be the victim who says, that's the guy. And therefore, you're going to see a much higher number of eyewitness cases than you would otherwise see. Most of our murder cases involve sexual assault / murder. And the reason is, again, we had semen or blood, but generally semen that we could use. If you simply have a hair found on the floor next to a dead body, you can get a DNA exclusion, but how do you know that that hair actually comes from a person who committed the crime? You don't. But testing semen was an extremely powerful way of getting at the perpetrator of the crime. And we knew we wouldn't meet resistance. However, when people have looked at other wrongful conviction sets in other parts of the country or in non-DNA cases in this country, that percentage for eyewitness misidentification drops considerably. Even if you looked at our own cases for murders, where it's much less likely there's going to be an eyewitness, certainly not a victim, testifying that that's the guy. It turns out that false confessions becomes the single greatest contributing factor. And the reason we say contributing factor in the underlying conviction as opposed to the cause is because we do not know exactly what was in the thinking of the jurors when they returned a verdict. But there's no question that there was a misapplication of forensic science. All the dangers of misidentification existed in the case that they're looking at. The variables which give rise to a false confession, which Richard will talk about in a few minutes, existed in those cases where people were demonstrably giving false confessions and were actually innocent. So those are the numbers. And then when it all began to change was in 2009 when the National Academy of Science took on the subject writ large. Previously, they had looked at individual forensic disciplines, written reports on them, questioning the reliability of polygraphs or voice prints or CBLA, dealing with bullet lead analysis. But here they did something very different. They said, my God, if we looked through every single forensic discipline and wrote a report on it and did a study on it, we'd be here for the next 75 years. And they continue to use these disciplines in an unchecked way. So in 2009, the National Academy issued this really groundbreaking study. And what was so powerful about this study and what made it a watershed moment was the primary finding. And the primary finding, which applied primarily to impression evidence, pattern evidence, whether it's bullet lead comparison, shoe prints, tire marks, bite marks, ballistics, fingerprints, anything like that, where you find crime scene evidence and you're comparing it to a reference sample taken from a suspect and you're trying to determine whether there's a positive association or an exclusion, is they reach this conclusion. With the exception of nuclear DNA analysis, however, no forensic method has been rigorously shown to have the capacity to consistently and with a high degree of certainty demonstrate a connection between evidence and a specific individual or source. Now that's 180 degrees opposite of what courts have been accepting in Canada and America for the last 100 years. It's a big deal. And the reason it's a big deal, in part, is that people never critically, not in any of the bite mark cases, shoe print cases, tire cases, in none of those cases did they ever think about, well, what are the key questions that we really need to think about before admitting this evidence? And here they are, okay? So there are two different hypotheses being proffered by the proponent of the evidence in a given case. One is, as a properly trained examiner, can he make a positive association between a question sample, this is hair I use as an example, and a known suspect hair? That is there a match, no match? Positive association, no association. Sometimes they use words like consistent with as opposed to inconsistent with. It doesn't matter what the words are. The studies indicate that just any of those words will have a profound impact on the listener. But the second question is actually, in some ways, even more important because people are more easily misled by it. And it's an issue that never gets raised in any of these cases. The second question is, okay, so you have the ability to reach an objective scientific result as to whether or not a hair found at the scene is consistent with the hairs on Neufeld's head. So what? Okay? So what? You need a properly trained examiner able to estimate, okay, the rareness or frequency of that association. Is the fact that two people have similar hair or that my hair is similar to a hair found at a crime scene, is that something you would expect to see in 1 in 5 people, 1 in 50 people, or 1 in 5 billion people? And the juror needs to know that. Because if the juror doesn't understand the importance of that positive association, the juror will have no way to evaluate the probative value of that evidence, plain and simple. And it becomes a much greater problem in scientific or so-called scientific evidence than in a layperson's testimony, because we all intuitively have some way or some ways of evaluating the credibility of an eyewitness, of a friend, or what have you. But we don't have that same intuition when we're looking about an expert. when the expert is talking about hair, fibers, bite marks, bullets, or fingerprints. In fact, in both your system of justice and ours, the reason we allow the expert to testify is there's been a determination that what they're testifying about is beyond the ken of the average lay person. So they get to say these things, they get to give these expert opinions, but unless we know the basis for them, then we're left in the dark. It's plain and simple. When you look at every single challenge made on bite marks in America, okay, what you find is no one ever questioned hypothesis 2. No one ever questioned that, even assuming for the moment they have a valid and reliable way of identifying positive associations, that they have been able to come up with an estimate of how rare or common that association is. In DNA testing, we have extensive, exhaustive databases so people can say scientifically, give an estimate on the frequency of a particular genetic allele. It's not that hard, okay? They've done it. And then they've determined that the presence of those alleles is independent of the presence of other alleles on other chromosomes. And so they can use the product rule and come up with a, in some ways, a conservative estimate, if they apply certain restrictions and rules, as to what is the probative value of that particular DNA profile over 13 markers. But without some kind of population study, you can't do that. There are no population studies on the frequency. And let's take Mr. Harwood's case. There's no databases on the frequency of people who have an incisor here that's slightly bent, or on the cuticle on a particular hair being a certain way as opposed to another way, or the pigmentation, on any of those factors. And all that happens is the expert is giving you a, out of his pocket sense based on his own experience that I don't see this all the time. Well, that's not science, okay? That kind of experiential perspective. Either you need some kind of empirical basis for it that's recorded and studied, or you need some kind of theoretical model. They have neither for any of these forensic disciplines involving patterns or impressions. We have another case. How close am I? How much time have I done? 7 or 8 minutes? Okay. So we have another case that we did. I talked about bite marks. I'll talk about hair. A guy named Donald Gates, who had just been released from the armed forces, was living in Washington, D.C. And Donald had a drinking problem. He gets picked up for just literally knocking a woman over in broad daylight while he's drunk, right outside the Watergate office building on the shores of the Potomac. And as a result of that, he gets identified in a lineup as being the perpetrator of a rape. And after that rape happens, there was a particularly vicious, horrible, high-profile murder of a young white student from Georgetown University in the approximate same location. And so the police begin to think he must be good for this as well. And so they recruit a snitch, and the snitch says that I heard Mr. Gates actually making culpatory remarks about the murder, but they realize that's not enough evidence. They finally bring in Mr. Gates. He gets charged with the murder. Then they want to see if they can go forward on the rape, and they find out he couldn't have committed that rape that made him initially a suspect in the eyes of the police, because he was serving 30 days for shoplifting at the time of the rape in the Washington, D.C. jail. And so he had an airtight alibi. So they dropped the rape, but of course the victim of the murder is dead. And so they're off to the races going forward on that case. They know they can't make out a prosecution just on the word of a snitch, so they send 2 hairs that were found on the deceased body off to the FBI crime laboratory. The FBI crime laboratory says they're a perfect match to Mr. Gates's hair, and so at trial, the combination of the snitch with the FBI hair examiner resulted in Mr. Gates getting convicted and sentenced to life without parole. Mr. Gates, after about 27 years in prison, DNA testing on the rape kit not only excluded him, but identified the real perpetrator as a temporary janitor who was working in the same office building as the victim on the night in question, who had followed her home from work and then attacked her 2 blocks from the office building. But as a result of Mr. Gates's case, we went back and looked at the transcript. And in that transcript, we saw that the FBI hair examiner had said, yes, it's a positive association, and based on the fact that I've looked at 10,000 other cases, and only in 2 cases was I unable to distinguish a victim's hair from a suspect's hair. Big deal, hardly, apples and apples. Most of these sexual assaults, you're dealing with women with longer hair versus men with short hair. Yes, you can distinguish them. Also, a priori that this is a reference sample that comes from the victim. This is a reference sample that comes from a suspect, so they came from 2 different people. Yeah, you can distinguish them. And said, well, based on that experience, I couldn't expect this to happen, so it's extraordinarily unlikely and improbable that these hairs came from anybody but Donald Gates. So once we went back and we looked at that testimony, and we showed it to the FBI, and we showed it, more importantly, to some of the leading statisticians in America, they said, that's junk, that's garbage. If you don't have a population study on the frequency of any of those characteristics, you have no basis saying it's extraordinarily unlikely that it came from anybody else. No statistical basis at all, no scientific basis. And so we got the FBI to go back, and they looked at other cases, realizing what they could say and what they couldn't say. And after looking at the first few hundred cases, they realized that in 95% or 96% of the cases, that the FBI agents offered testimony that was scientifically invalid. They had given testimony that exceeded the limits of science in all those cases. And as a result of that audit, many of these cases are now being reopened. Just last month, in one of the cases where they could no longer recover the hairs for DNA testing, the judge nevertheless said there's been a change in the understanding of science of hair microscopy, so we will simply throw out the case. And this would be the kind of typical errors we would see in the transcripts. First of all, you'd have individual sourcing. The FBI agent would be asked the question, can you look at a hair and determine what particular person it came from? Answer, to a reasonable degree of scientific certainty, yes. Well, there's no scientific basis to support that statement, none at all. Second, now, and this is a different kind of error, now it's possible for 2 different people's hair to exhibit the same uniqueness, odd expression, but it's very rare. It happened on occasion, but in general terms, it would be a very low degree of probability of it happening. Well, the only way you can use words like low degree of probability or high degree is if in your mind you have some number attached to that, right? Because low probability to you might mean 1 in 3, whereas to me it's 1 in 300. So there has to be some number when someone says something has a high or low probability. But of course they don't have any numbers because they don't have any databases. So that's another kind of error. And the third kind of error, which we saw in a lot of the cases, was the one I just told you. I personally have looked at hairs from 10,000 different people, and over that time I only had 2 occasions out of 10,000 where I had hairs from 2 different people that I could not separate them. Of course, they never did pairwise comparisons on the other 9,999 cases. They never compared the defendant's or victim's hair in the 10,000s case with the reference and victim samples from the other 9,999. They kept no records on characteristics. They just did it out of their head and out of their memory. That's not science. But that passed for science in conviction after conviction after conviction, and they were all affirmed on appeal. That's how it simply worked. What instead is we got the FBI to acknowledge that for hair, and frankly for these other disciplines as well, that all they could say, even if they had an hypothesis, a hypothesis 1, demonstrable. And frankly, they haven't done that yet. They haven't done it for hair, they haven't done it for bite marks, they haven't done it for most of the other pattern and impression disciplines used in Canada or the United States. All you can say is that, at the broad class level, that a contributor of a known sample could be included in a pool of people of unknown size as a possible source. So obviously, when you put in that kind of disclaimer, you are significantly reducing the probative value of the evidence, but you're being scientifically honest. And that's where it's at with hair. That's where it should be at with many of the other disciplines. The other thing I wanted to briefly touch upon, and I'll throw this open to discussion, is it's not enough to go back and require an assessment by scientists of the validity and reliability of the discipline. But when things go wrong, you have to conduct an audit. You have to see whether or not the error that you've encountered happened once, right? It's an outlier. Or is it a repetitive error done by the lab, done by the community? You had your own, the Gogue Inquiry in Toronto involving forensic pathology. They found that there were lots of cases where the testimony was simply scientifically invalid. There have already been a half a dozen exonerations flowing from that inquiry. You had another inquiry in Manitoba involving hair microscopy. There were 2 exonerations that came out of that. You have to do an audit. You know, if you ran a bank and you found that a cashier had embezzled the transaction, if you're the vice president, you say, oh, he embezzled the transaction, thank God we caught it, and just move on? Or do you think if he embezzled one transaction, there's a chance he may have embezzled more? You do an audit. And if you do an audit over money, you should do an audit over life or liberty. That's all we're saying. And the more you do these audits, like the Gogue review or the review that we're doing at the FBI on hair, the more likely you are to get justice. Now, the other thing we did in the United States is, as a result of all these wrongful convictions, the President has established a National Commission on Forensic Science. I sit on it, and we're coming up with recommendations on how to improve the delivery of forensic science in the States. And one of the first things we did is come up with a code of ethics. And the code says, okay, that when things go wrong, you do a root cause analysis. You find out what the causes were of the problem. Was there a lapse of oversight? You know, what we found with the FBI is no one was reading the transcripts of their own examiners all over the country to see if they were scientifically valid. Instead, they would send out a one-page questionnaire to the prosecutor and say, hey, did my woman do a good job? Well, we got a conviction. She must have done a great job. That's not science. That's not meaningful oversight. So that all has to be changed. Not only do you do a root cause analysis, but then you do the audit, the kind of audit that we're talking about. And when you do the audit and you find that something went wrong, one of the things that our commission did is we passed a code of professional conduct, a code of ethics. And what it says is, if you find out that there was an error, then that error would have affected a report that was already written. Then you have a duty, an ethical duty to correct that report with a new one. And you have a duty, an ethical duty to notify anybody who was adversely affected, okay, by that error. Anyone. And what's happened in the past is that when labs find these errors, they simply notify the prosecutor. But what this code of ethics says is you also have a duty to notify the defendant, because certainly he or she was adversely affected by the error. And that's something new and something that we intend to spread to all the different forensic disciplines. Realize that DNA is not a panacea, that, as pointed out before, I think, biological evidence only exists in a very small minority of cases. We who are part of society have to do everything that can be done to make the criminal justice system more scientific, more robust. And frankly, whether it's forensic science or eyewitness identification or the interrogation methods used by police in Canada or the US, there has to be some scientific basis for what they're doing. And if the scientific underpinnings of those methods fall short, okay, then we should apply the same scientific rigor that I'm talking about for the hardcore forensic disciplines to interrogations or eyewitness methods, to demand that the most scientifically robust methods are utilized to investigate crime and to adjudicate crime. And if we do those things, we're much more likely to get to a reliable and just result. This is a picture from just 2 weeks ago. The guy I started out talking about in this talk, Keith Harwood, on April 8th, after the DNA cleared him and identified the real perpetrator, after almost 34 years. He goes in at age 26. As he leaves the Navy, he comes out at 60. Okay? 2 weeks ago. That's Keith Harwood walking out of court in Newport News, a free man for the first time. Thank you very much. Questions? Comments? Yes?
I'm trying to figure out how to make my mic work. Okay. I have a question. You said your database, as opposed to one, was at University of, was a state, started with an F.
I'm sorry, could you speak up a little bit?
Oh, sorry, now it's working. You said that your database versus a much larger database that was at a university, Minnesota or Michigan, you said, do they test other things? Because you guys concentrate on DNA, right? So,
yeah.
So do they bring in, like, for example, for bite marks, there are some scientists, like we have one here at UBC, David Sweet, that goes to the States and testifies for people who were convicted like 30 years ago and says, wow, you know, they didn't know what they were talking about. Here's the current stuff. Does that university do that for their cases that are in their database?
Well, those are two separate issues. So,
oh, sorry.
The Sweet, I believe, has also testified for the prosecution to include certain people as the source of bite marks. It's my understanding that his testimony is not limited to post-convictions and looking at old cases. In fact, we've had, I mean, you know, unlike other types of forensic disciplines where you can go back to the crime laboratory like we did with hair and they have records of the old cases, since the forensic dentists are freelancers like Dr. Sweet, the only way we're going to get a database to review all those old cases is if the forensic dentists cough up the lists of the cases they've worked on.
Okay.
And we've asked them to do so, and so far they haven't done that. When you asked about the other database at the University of Michigan, what I was talking about was our database has about 340 or so cases in it. Those are all people exonerated by DNA. The database of the University of Michigan, which I think is now over 1,700 exonerees, are people who are exonerated without DNA. So you have the real perpetrator being apprehended, making not just confessions, but also walking the police through the crime scene and pointing out things that even the police had missed before to corroborate that confession. You have key witnesses who recant and explain that the reason they gave false testimony in the past is they were coerced into doing so. There's no DNA in those situations. So their data set of wrongful convictions, which is much higher than ours, is not limited to DNA. We think it's advantageous to use both data sets for different purposes. Certainly the Michigan data set gives you the sweep and extent of what the problem is. And frankly, neither database covers wrongful convictions for misdemeanors. And intuitively, I think more people are wrongly convicted of misdemeanors than felonies. Because I used to represent people as a public defender who would say, I just can't go back to court again. I'm going to lose my job. I'll just take the plea and pay the fine.
Yeah.
Right? Even though they said, no, I'm innocent. So God knows how many times that's happened. But that's the reason for the two databases.
Okay, thanks. Sorry, follow-up DNA question, which I forgot. I've seen a lot of documentaries and read stuff about cases where DNA exonerates the person, but then everybody involved on the prosecution side still won't let the person out of prison because they say, oh, okay, now our new theory is 2 people did it. Have you had that in any of your cases? Like I noticed especially Texas, I think, likes to do that.
Well, they did do it, okay. But they don't do it that often. Okay. In fact, I'm about to do the Innocence Project's first retrial. It's going to be in Philadelphia starting in August. It's our first one in 25 years, and it's exactly that. An 80-year-old widow is attacked in her home, very proper woman. She's raped and murdered, stabbed repeatedly, and all attention focuses on this one guy, Tony Snyder. You can read about it, look up Tony Snyder in Rolling Stone. There's a long-form article on it. Tony was somebody who had assaulted an officer and just got a wrist slapping from the judge. And the police were very, very angry. And they didn't solve this murder right away. And so they attributed it to Tony. They brought him into the station house, and they said he immediately confessed without any interrogation. DNA testing was done recently and identified Tony was 19 at the time, identified a 40-year-old crackhead who lived as a squatter in an abandoned house a half a block away from the victim. What the police are saying now, and the prosecutor is saying, oh, his confession was true. He lied about one thing. He said he acted alone. In fact, he acted with this other person who was twice his age and for whom there's no evidence that they even knew each other. And they're going to retry the case in August. Man. But generally speaking, they may start out with the unindicted co-ejaculator theory that you're describing. But it's sort of like this. I'd love a psychologist to study this. I call it the arc of denial. And eventually, after they work it through and the guy has been out for a while, they'll realize they can't retry the case.
Okay.
Not only can they not retry the case, but indeed, he is innocent. So that's what happens usually. The case in Philadelphia is an outlier.
Okay, cool. Thanks.
I just wondered if you can comment on, generally speaking, from a practical point of view, how difficult it is for the average defendant to challenge for forensic evidence, and how the rules of evidence in most criminal trials make it exceptionally difficult to challenge the underlying science behind most forensic opinions. And the example that I just want to give you is that most of the discussion about forensic sciences is going to take place in the scientific literature. And short of having your own expert, how difficult it is to put that scientific literature to an expert. And in fact, what the system promotes is that the least knowledgeable expert is more likely to be accepted, because if they don't have any knowledge of this other scientific literature, it's not admissible in court, because if they're not familiar with it, they've never read it, it can't have any weight in the proceedings. And that's structurally one of the immense challenges to dealing with forensic evidence.
Well, I think that's a good point. That is structurally one of the main challenges. But I would even go 2 steps before that and say that the forensic discipline hasn't even been evaluated by mainstream academic scientists in related disciplines. That mainstream academic scientists are doing their research work and publishing their papers on areas that the National Institutes of Health or the National Science Foundation has chosen to fund them for. And there's very little funding in America for forensic science. And if there's no money, people don't write about it. And so the only people who tend to write about it in 1 or 2 very industry-specific journals, like the Journal of Forensic Science, and the people who are writing those articles are not top scientists. Okay, they're members of the profession. And so you have an echo effect of people reading what they want to hear and the things that they heard before. Okay? There's no meaningful challenge or refutation of the underlying hypotheses being proffered by the author. It doesn't exist. And so there are so many obstacles against a meaningful challenge, from the fact that of what I just said, of what you just said, to the fact that most forensic science appears in crimes of violence, and in most crimes of violence in both Canada and the United States, the suspect tends to be somebody of limited financial means, more likely to have assigned counsel, even though you have a slightly different approach here in Canada. That lawyer and that client doesn't have the same financial means to go out and get Nobel laureates to testify on their behalf. Whereas when Dow Chemical is sued by somebody else, the defendants line up the best possible witnesses in the world. So money, class, and race play huge factors in why there is no meaningful review of the forensic science. That's why what we're asking for, finally, at the National Commission on Forensic Science, is that the United States set up a mini FDA for forensic science, of dispassionate, independent, scientific body that can actually review all the forensic science disciplines, determine whether or not they've been validated, determine their reliability, identify the parameters beyond which they're no longer valid and reliable, and set it all out. And it doesn't have to be a big, unwieldy regulatory body like the FDA. The group that we have in mind is a sub-agency within NIST. NIST is the National Institute of Standards and Technology in the United States. They're scientists who don't have a dog in the fight, not pro-prosecution or pro-defense, but they're pro-science. And we're not asking them to do all the original research. People who have done research could present it to them. They will evaluate it, and they will assess validity and reliability. If that's done, then courts of law and scientifically illiterate lawyers will look to the NIST pronouncements for guidance on what belongs in a court of law and what doesn't. And any reform short of that will fall way short of ensuring that only valid and reliable forensic science is used in serious criminal cases.
I wanted to add one thing. You made a very important comment about learning from our mistakes. Many people here would be astonished to know, and other disciplines would be astonished to know, that many of the wrongful convictions that we know about, Mr. Milgaard's, Guy Paul Moran, those cases go into the Court of Appeal or even the Supreme Court of Canada, are still relied upon today as precedent-setting, for precedent-setting legal principles. And they're cited routinely, every day in courts, for precedent-setting legal principles. That's the extent to which the system doesn't learn from its mistakes. How on earth a wrongful conviction can justifiably be relied upon for a legal principle? I mean, it's insulting to the exonerees to some extent, but that's the system.
So all the cases in the United States that are published are finally published by the Westlaw Publishing Company, and Brandon Garrett has written a letter to the West Publishing Company that from now on, all cases which are cited for anything, if they resulted in a wrongful conviction, there has to be an asterisk there explaining that. So they will lose their precedential value. You're absolutely right about Canada and the U.S. I mean, you have one huge advantage over us. You have these commissions of inquiry, and the commissions of inquiry are the equivalent of a national root cause analysis as to what went wrong. In the United States, by comparison, these cases are simply swept under the rug. They appear in the newspapers and TV for the 15 minutes of fame, and then that's it. It's back to business as usual, unless there are people like yourselves who are willing to say, not so fast. We really need to engage in systemic reform. And unless we change those structures, we're doomed to repeat those same errors in the future.